Good morning. This is the second video for our 2020 criminal procedure class. This morning, I want to cover a couple of cases that we have not covered and go over Jardines and Collins so I can make certain that you all have a clear understanding of what Jardines and Collins have added to the definition of a search. And then I'll go on and I'll cover Greenwood, which deals with the search of garbage or search of materials outside of a home, but they are closer to home, but not really part of the curtilage. Then we move on to Kyllo, and Kyllo actually deals with the search of a home, and then to Bun, the search of the baggage that's been transported on a bus. When we started off on Wednesday, we started off with the case of Florida versus Jardines, and again, I apologize for posting the wrong case. But anyway, in Jardines, we had the officers coming onto a person's porch, with a trained drug sniffing dog for the purposes of doing an investigation. Now, the question in that case became, and well, when he brought the dog onto the porch, the dog alerted. The dog alerted on the porch, which indicated that there were drugs inside of the home. Once the dog alerted, the officer went and he got a warrant, searched the home, and he did find drugs. So the question becomes, can the officer conduct this search in the curtilage with a drug sniffing dog? And as we said on Wednesday, a dog drug sniff is not a search because the only thing that it reveals, only thing that that dog is trained to reveal is the substance that has been trained and that is mostly illegal drugs. And there's no expectation of privacy in illegal activity. But here, the problem is that he marched the dog around the house. And we found that the area in which the dog actually conducted the sniff was the curtilage. That is the area that is immediately in the immediate vicinity of the home and immediately associated with the home. And in order to answer the question as to whether the search of that curtilage or using that dog, that drug sniff dog, in order to make a determination as to whether there was whether it was a search, the court looked at the curtilage and said the curtilage had practically the same expectation of privacy as the inside of a home. There's some limits on it. But it says in that curtilage, a person should be able to retreat to his yard. He should be able to retreat to his porch and not fear government intrusion upon his porch or government intrusion in his home. But the court used a two-pronged test in order to make this determination because the basic rule is also that the government does not have to avert its eyes to things that it may see or illegal activity that it may see that is open to the public, that is in plain view. The government does not have to avert its eyes. However, the court said that the curtilage is a place where, again, intimate activities occur, and therefore that in order for the government to infringe on the curtilage, to walk onto the curtilage, to do something in the curtilage, they must determine whether the person is or whether the officer of the government is an invited guest or a licensed guest, and licensed invitee, they called it. Now, this test is based upon societal norms and societal expectations. And the court went on to say that it is not normal for a person or for the government to come onto a person's porch and bring a drug sniffing dog. To bring a drug sniffing dog is the first prong of the test. We look at what societal norms are, what societal expectations. What does society do? They said that a licensed entrance onto the porch is what society would do. You have Girl Scouts who come to the porch. You have other peddlers who come to the porch. And they will knock on the door. They will wait on an answer. And if there's an answer, they speak to the person who answers the door. But if there's no answer, they will leave. And so the government can do the very same thing. But here, when he brings on a dog, it becomes an unlicensed invitee. An unlicensed invitee is one who would do something that is not within societal values or societal norms. Secondly, they said, not only must we look at what society expectation of privacy that society consider to be reasonable based upon societal norms, is that we must look at what is the purpose for the government going onto the property. And here the purpose was to conduct an investigation. The officer had received information that the homeowner was engaged in drug trafficking. And based on the information, he went in and he took a well-trained drug sniffing dog for the purposes of investigating for drugs. And so the court said that the public will generally not do that. That's well beyond societal values. And thus, because it fails the two-pronged test, it's not reasonable that the public would come onto a person's property with the drug sniffing dog for the purposes of engaging in a criminal investigation. And so the officer's purpose is important. Whether he's a licensed, whether he is a licensed invitee or a licensed intruder, depends upon what society would expect and the officer's purpose for entering into the curtilage. And entering into the curtilage is also synonymous with entering into the home. When I say synonymous, it's going to be given the same protection under the guise of Jordan, or under the rule that Jordan has promoted. Now, this next case that we covered dealt with Collins. Collins was an interesting case. Collins, officer encountered a person on a motorcycle, and as usual, person on the motorcycle was speeding, and officer could not catch him. And so officer saw the person a second time. He says that's the same motorcycle. He's still going, he's still speeding. Then officer began to do some investigation on the motorcycle and found on the owner's, or the person who was driving the motorcycle's Facebook page, that it was probably a stolen motorcycle, and he also got an address. Officer went to that address, and when he got to that address, they saw something outside of the home in the curtilage, and it was covered with a tarp, and it appeared to be a motorcycle. But the officer, to get a better view, he went onto the property, he lifted the tarp, he looked, and it was the orange motorcycle that he had seen that had been speeding, that had been violating the law. Officer, based on the information, got a warrant, went back, met with the person, and he arrested him. Now the question becomes, can the officer go on to the curtilage even though he has probable cause to believe that motorcycle exists there on the curtilage and the motorcycle has been involved in criminal activity? The court said no. The court said no. And what the state tried to do, or what the government tried to do, the government tried to say that, hold it, this is automobile search. Here we actually believe that the motorcycle was involved in criminal activity. We have probable cause to believe that the motorcycle is involved in criminal activity. And if we have probable cause to believe that the vehicle is involved in criminal activity or it contains criminal evidence of a crime, then we have probable cause to conduct a search of this particular vehicle. But how did they get to the vehicle? They went to the curtilage. They went to the curtilage and he conducted a search when he lifted the tarp. And the court said that the rules in reference to the curtilage trumps the automobile exception. And the automobile exception does not apply here, because generally what happens is that not generally what happens, I apologize. The rule is that the automobile exception applies to automobile and not to the curtilage. And the home, again, is first among equals. And the curtilage is considered to be a part of a home, an essential part of a home, where intimacies of the home are carried on. And so, therefore, when he entered into the curtilage, he violated the rule in reference to the home and that sanctity that the curtilage is given. The curtilage will trump the automobile exception. And so even if the person had probable cause to believe that it was a car in the carport and it contained evidence of a crime, he had to get a warrant. Even if people believed, and it was really interesting, the court said, that the car was sitting in the house in wide open view. And in order to get in that home, the court said he had to get a warrant. But the court went on to say also something that was really interesting. They said if he was trailing him and he was following him and he followed him onto the curtilage, that would have been fine, because he was at that particular point, the person was violating when he was following him, if the person was violating the law, then he can follow him onto the curtilage because he has probable cause at that particular time, and that the person, and he's in hot pursuit of the person who goes onto the curtilage. Let me say that again. I kind of bundled it up a little bit. I want to make certain you understand it. If he was following a motorcycle, and the motorcycle was speeding, and the motorcycle swerves off and goes to the curtilage in order to get into the home and believe that he's going to be protected, he's not protected, because at that point the officer has probable cause. The officer has probable cause because he's seen a crime committed. He has observed a crime being committed, and he has a right to arrest that person who has committed a crime. And the person goes to what he believes is a safe place. The officer is pursuing him. That is hot pursuit, and therefore going into the curtilage will be permitted. It's part of the exigent circumstances exception. Now, the next case that I want to cover is Greenwood. Greenwood is a really interesting case. Look at Greenwood. Greenwood deals with garbage. The government believed that Mr. Greenwood was involved again in drug trafficking. They got a tip that he was selling drugs, and they did some surveillance of his home. They saw people going in and out that they believed were involved in drugs, and the officer who was in charge of the investigation wanted to take a look at Greenwood's trash for the purpose of determining whether he was disposing of things that were related to a drug operation. And he asked the trash collecting company to actually gather Mr. Greenwood's trash. Do not mingle it with other trash, and to get it to the police department. And the trash department did that. The trash department actually cleaned out the bin. They went to Mr. Greenwood's home. They gathered his trash and they brought it to the police department. Once at the police department, they went through the trash and they found information that was related to drug activity. Based on information, they got a warrant to search Mr. Greenwood's homes. Mr. Greenwood said, hold it. My information was in opaque bags. I closed it on opaque bags and I put it on the street where I was required to put it. I was required to place this on the street. And therefore, I have a reasonable expectation of privacy because of what I have done. I have placed my bag on the street according to what the vendor required me to do, the garbage collector required me to do. And I also placed it in an opaque bag. Therefore, I had a subjective expectation of privacy that society is willing to say that is reasonable. In that case, it's really interesting. The court said, let me read it to you. We conclude that respondents expose their garbage to the public sufficiently to defeat their claim of Fourth Amendment protection. It is common knowledge that plastic bags left on the side of a street are subject or readily accessible to animals, children, scavengers, snoops, and other members of the public. And so they said that it's accessible to the public. Remember what we said? If it's accessible to the public, it's also accessible to the government. They said that animals can get in it, children can get in it, scavengers can get in it, snoops can get in it, and any member of the public. So if the public has access, the government has access also. The second thing they said, moreover, respondents placed their refuse at the curb of the express purpose, for the express purpose. Let me start over. Respondents placed the refuse on the curb for the express purpose of conveying it to a third party, the trash collector. Once you convey it to a third party, you run the risk that the third party will hand it to the government. And so you assume the risk. That's a new dynamic that we're looking at. That once a person gives something to a third party, he assumes the risk that that third party will hand it to the government. And so you have to be careful what you give to a third party, information that you give to a third party. And thus, the court found that there was not a search because of those two exceptions. And therefore, the warrantless search or the warrantless taking of the bag and the going through the bags was permitted. Now, there was a really good dissent here. And if you get a chance, I suggest that you read the dissent that was done by Justice Brennan, and joined in by Justice Marshall. Basically, what the dissent says is that this shocks the conscience of the public, that the framers would roll over in their grave if they thought that someone could go through your trash, that in your trash is included the most intimate things in your life. In your trash, you throw away your medicine many times. In your trash, you throw away things and you hide it and you bounded it so that others cannot see it. And you expect for it to go to the refuge and not to be given to the government. And so it would shock the conscience. And we cannot believe that we go so far as to say that the government can go into your trash in order to investigate you. Very good dissent. Next, and one thing that came out of Greenwood, which was really interesting, a case that followed Greenwood, a 1989 case, it was an Eighth Circuit case, United States versus White. In United States versus White, this case was not assigned, but I found it to be really interesting. In United States versus White, the government believed that a person was expected of some criminal activity. He was expected of handling drugs. They followed the person into a public bathroom at an airport. And while he was inside of a stall in the public bathroom at the airport, government employee, federal agent, peeked through the slit in the doors, the crack in the doors of the stall, and saw him engaging in some public activity. And the government says, or the Eighth Circuit says, there's no reasonable expectation of privacy in the stall in a public bathroom. The public has access. Now, do you expect anybody to be looking to the stall while you're using the bathroom? The next case, and the last case I want to look at, no, the next case, it's not really the last case, but the next case is Kyllo versus United States. Kyllo versus United States, again, deals with drugs. Officers believe that, and got notice or tip that Kyllo was growing drugs or marijuana within his home. In order to grow marijuana, you have to have an astronomical amount of heat. You have to have a great deal of heat in order for those plants to grow. And so what the government did, they set up shop outside of Mr. Kyllo's home, and they used a thermal imaging device in order to determine the amount of heat that was coming off the walls of Mr. Kyllo's home. And there was much more heat that was coming off the homes of coming off the walls of other homes. They measured the heat on the outside of the walls. They used that information to get a warrant in order to go into Mr. Kyllo's home. And what did they find? They found drugs, right? But Mr. Kyllo says, hold it. You invaded my privacy. That the home is first among equals. That the home has the greatest degree of protection here. And once you use that for the purposes of making a determination of the heat that's coming out of my home, you've invaded my privacy. The government says, hold it, we have not. We have not invaded your privacy. Number one, because we did not measure the heat inside of a home. The heat that we measured was the heat that came off of the wall. And that heat is disposable heat. That heat is heat that's coming off of the wall outside and not anything on the inside. And therefore, we did not violate the intimacies of the home. But the court here said something that's really important. It does not matter that they did not violate the intimacies of the home, that they had the ability to violate the intimacies of the home, that the intimacies of the home were open to them, even though they only measured the heat that came off of the wall, and that this device could determine where people were in the house based on the amount of heat that's in the room, could determine whether the missus was taking a shower. It could determine intimate things, many things within the home. And therefore, because it has the possibility of determining the intimacies of the home, it is a violation of the Fourth Amendment. Let me read to you what the court said. We think that obtaining by sense-enhancing technology any information regarding the interior of the home could not otherwise have been obtained without physical intrusion into a constitutionally protected area constitutes a search, at least where the technology is within the general use of the public. Again, we
Okay,
think,
I found this on the web for
we
search
think,
fees. Where analogy.
we think that obtaining by sense-enhancing technology any information regarding the interior of the home could not otherwise have been obtained without which could not otherwise have been obtained, without physical intrusion into a constitutionally protected area constitutes a search. Therefore, it doesn't matter whether the person or whether they actually went into the home. It is the fact that it could have invaded a home. The Fourth Amendment's protection of the home has never been tied to the measurement of the quality or quantity of information obtained. At the home, our cases show all details are intimate details because the entire area is held safe from prying government eyes. These were intimate details because they were details of the home. They had the ability to do it, they had the possibility to do it. Therefore, it was a search. The home is given the greatest degree of protection. Nowhere else is the possibility to engage in the search. It's actually a search. In every other instance, the possibility to engage is not enough, except for when it comes to the home. The last case deals with bond. Bond deals with person having baggage on a bus. The bus is traveling from Texas to Arkansas, I think, or somewhere. But anyway, it stops at what's considered to be a border stop. Stops at the border stop. Agent goes into the bus for the purpose of checking and make certain that everybody on the bus is legal. He walks through. He finds that everybody is on the bus is legal, and then on his way back, after he's gone to the back of the bus, on his way back to the front of the bus, he grabs a bag and he begins to prod it. He feels the bag, he prods the bag, he pushes the bag with his hand, and he feels something that seems like it's a hard brick, and he believes that it's drugs. He goes in, he pulls it out. Lo and behold, it is drugs that are wrapped in a brick-like shape, and the person is charged with possession of a controlled dangerous substance with intent to distribute. He says, hold it. What the officer did was a search. Government said you have no reasonable expectation in a bag that's in the public. The court said, hold it. The bag has certain degree of protection. Your luggage, your bags, because of what they contain, have a heightened degree of protection. In your bags, again, you're going to have the intimacies of your life. You're going to have personal things in your bag. And because there are personal things in your bag, the courts will give them a greater degree of protection than they will give ordinary things. Thus, the court said that is not what the public could do here, is what the public would do. The public would not take your bag and they would not prod it, they will not pull it to make a determination as to what's in it. Yes, the public may move your bag, the public may push it to the side, the public may take it down and put their bag there and put your bag back in it, but they're not going to prod it. They're not going to engage in a tactile outside investigation of your bag in order to make some determination as to what's inside of the bag. And therefore, the court found that that was a search. That's the end of my presentation. I went a little bit longer than I wanted to go, but I had to get through these cases, and we'll see you all on Monday. The quiz will be posted, and you'll have until 1 o'clock on Saturday to complete the quiz. Thank you so very much.